Hi, I'm Natalie. Hi, where are you from? Hi.
Hello, I'm Hadi.
Hi, Hadi. How are
Hi,
you?
how are you? Nice to meet you.
I'm standing. I'm standing
Yeah.
for you.
I think so. I think I'll do that as well.
I really like I want to see, I can't try. Yeah.
I have to give them my I don't know who.
Give it to Betsy. Where's it to Betsy?
Ah, yeah.
Hello, hello. Oh, hello. There's a small world. Yours?
Yeah.
Well, your family's out there.
Yeah,
Right. I think I come from your place.
Like everything. Yeah.
Don't you not have a woman father?
Yes, and a Democrat. And she's bisexual.
Really? Attractive. Looks like in Arizona. You know, that's what Arizona was that.
She doesn't have anything to say.
Yes, totally. Exactly.
You're like, suddenly.
Yeah. Is it everything now? Like,
No, she's young. She got more progressively more ambitious, but
and we have.
it is what it is. She's what? Like
I know, exactly. There's nothing, she didn't do anything wrong, as far as I'm concerned.
No.
Right.
I'm saying
Yeah.
somebody
Good.
got
Right, so, that's, when I was in Myanmar, you were there.
I know, but
But
it's
we
because
had
you
the
were there
best.
during the
I know that, well, I think I was there because they didn't have any way to go to the toilet. But we had a ball. You met Sam Roberts.
I never did.
We had so much fun. We had so much fun. We went for New Year's. What did I call it? I call it Disney Lake, but it's not called Disney Lake. Is that what it's called? Yeah. No, the one with the guy, you know. Yeah, but they also.
They row with the feet.
And so, did you know one another?
Yes, we
met yesterday in one of the...
Hi.
Nice to meet you, Daniela.
Daniela, hi, Natalie.
Hi, how are you?
Look, we're mostly women, and therefore we will be sticking to our time, because if we're talking about gender-based violence, I will talk about gender time violence. Gender time violence. Yeah. How are you? This is interesting. Okay. You're lovely. I went to Johannesburg. I lived in Argentina. Yeah. Were you in the
I was in the...
book? I found it very interesting, and I was in Africa yesterday. It was really, it was a vice translator because there was some French people in it. And it was great. It was great because it kind of a very little knowledge of what you do. It's a very interesting thing, and I found them, and I really, really? Yeah, because when it was quite, like bar association, it was say, but then everybody seems to be very open, and process. They had an app. They were in a delay the rest of the first work. So I'm very ready to speak so excited. I will go that far. I think we'll tell them that it's easy. And you? This is my office. Where? At the Legal Aid Society in New York. Yeah. I mean, we have 8 people.
I'm trying to make sure I have everybody's presentations. Did you have a presentation? A PowerPoint? Okay, just making sure. And I got the boss.
Yes, boss. Yes, boss. Yes, boss. We did everything we need. You want us to leave now? We're going to stick to our time.
Are you?
Yes, they're all women except for this gentleman. And then he'll be able to go over time at the end. With
give them as much starting information as it's possible for the sake of more effective legal aid to special groups. After a lawyer has been initiated into a legal aid system and starts working, sharp and relevant to the international and national practice, as well to the newest legislation. After trying our different models, we came to appreciate the cascade training model as the most effective in the context of an extensive legal aid system. It's a very cost-effective model that allows to attract foreign and national experts to a single locality, disseminate their knowledge and skills among specially selected and prepared national lawyers, trainers of a legal aid system, and then extend them to regions and separate localities, possibly training new trainers, even there, and enlarging the network in a geometrical progress. Here you may observe the current standard compliance control system. While it is rather effective, it is retroactive, and we are now moving, as I have already mentioned, to more proactive approaches, such as peer review that will be implemented by the newly established Commission on Expert Legal Analysis that we will talk about further in the presentation. Right now, to keep those who successfully comply with the standards of legal aid provision result-oriented, we have a system of financial incentives. Positive coefficients are applied to the standard of tariffs, depending on the results of their work. But being result-oriented as it is, such incentive system forsakes the process of legal aid provision, thus being directly unrelated to standard compliance. Moreover, as the result of a case is a positive or negative, may not always be contributed to the efforts of a lawyer. Therefore, we are now working on changing it to a system that would be process-oriented. To further ensure the sustainability of our services, we are currently working on implementing several operational and institutional modifications, some of which have already been mentioned on the conference. The most important of them are Commission on Expert Legal Analysis, the Institute of Independent Legal Aid Provider, the Supervisor Board of the Legal Aid System, and the Wiki Legal Aid. The Commission for Expert Legal Analysis is an institution created jointly by the Bar, Legal Aid System, us, and civil society to implement in Ukraine a new level of quality management system, peer review. Established this month, its overall goals is to create mechanisms necessary for independent external review of the case files of the legal aid lawyers, develop a pool of experts from bar that could conduct such a review properly, and advocate for legislative amendments necessary for implementing the independent expert review system. An expert legal review is to commence in two stages. Firstly, by peers, specially trained lawyers, experts from a region different from the region of operation of those who have been assessed, of 5 randomly chosen cases of each legal aid lawyer for a time period that is still in the process of discussion, but not less than 10% of all cases regarding the vulnerable categories, for example, mentally disabled persons, who later produced the relevant reports where application of each standard is assessed on a grade basis for each case file, including a short conclusion Secondly, the Commission reviews the reports of a given lawyer expert. Commission may then change the result of a lawyer expert assessment if deems that fit. ILAB, International Legal Aid Provider, is an institution or organization created at the grassroots level, territorial community, joint territorial community, and aimed at equality satisfaction of legal needs and legal empowerment of the given community and its denizens. It follows a system vision on transition from personal legal aid service to legal empowerment of the community so that sustainability of the legal aid results could be achieved, and due to its grassroots nature, it allows for reaction time and customization that could never be possible for centralized institution. With the help of the Canadian government and Quality and Accessible Legal Aid in Ukraine project, as well as with the hand from the Council of Europe office in Ukraine and such distinguished experts as Mark Benton and Peter Van Bigelar and Alan Patterson, Ukraine is now implementing the Institute of a Supervisory Board based on the best European and Canadian practices and created to ensure the effective implementation of the state policies in the legal aid sector, independence of the legal aid system, strategic vision for the legal aid system, risk management, and transparency of operations. The membership in the board is to be formed based and open and transparent competence-based contents, so to evade the imminent conflicts of interest that arise when the membership quotas are disseminated between the interested parties, and to ensure its efficiency and reliability. Of importance is also the Wiki Legal Aid initiative. To put it short, it's a database of legal consultations that is routinely being contributed to by our lawyers and experts based on their best practices and expertise. While it's not yet available for public, we plan to make it so after completion of the most common question and evaluation, so that people could easily access legal algorithms online. And thank you for your attention and this possibility. Thank you very much.
Thank you very much, Mr. Branyuk, for a very interesting presentation. So we all can agree, I guess, that we write down the questions that we all have and ask at the end of the session. So we all can ensure that everybody is having equal time. So saying this, and I would like to introduce Mrs. Daniela Vitaliano. I hope that I pronounced the name correctly. Public defender from Brazil. I'm very excited and interesting to hear your experience. So, yeah.
So in first place, I would like to greet all my colleagues and say that it's an honor to be here and share all these experiences and ideas that will sure enrich our work when we go back to our countries. Nowadays, I'm the coordinator of some programs of access to justice and strategic litigation in the Public Defender's Office in Rio de Janeiro, Brazil. And today I would like to share with you an interesting experience that we are developing in Rio regarding the raise of the persons in prison who don't have a birth certificate. What stops them from to exercise the full rights from the citizenship that's one of the foundations of our republic. It's important to mention that we are a little more than 800 public defenders in Rio, and we are responsible for civil matters, criminal matters, and family, and every issue for all the poor and vulnerable people who come to us. Although Rio is one of the richest states in Brazil, we face a high rate of poverty, and our public is very, very large. Thousands of detainees in Rio have no formal registration and consequently no ID. This situation leads them to invisibility because they don't exist towards the state. Having no ID means not being a citizen. One can vote, can study, can't reach healthcare system, can't have a work permit, and after they leave prison, after they get released, their situation is as worse as possible, as they are now former detainees and rejected by society. This project, in partnership with other institutions like the judiciary, the prosecutors, and social workers, and Secretary of State Penitentiary, is important because they will be at the end formally registered and appear as individuals exercising their rights. And the first thing that was done was to create a working group, an interinstitutional exchange with these institutions, like the ones I told before. We have a universe of around 52,000 detainees in Rio, and many of them have no identification. It must be said that there was a significant increase in the prison population, which in 2013 had 36,000 prisoners, and this year the number has reached 52,000 prisoners only in Rio. In Brazil, we have more than 700,000 prisoners, and we are the third largest prison population in the world. When the inmate enters the system, criminal identification is given to him or her, and this one is different from the civil identification. This number doesn't allow them to exercise their citizenship when they get released. The most obvious thing to be done would be to implement the identification at the entry ports of the system, but it just doesn't happen. So a schedule of actions was established with the aim to eradicate the lack of registration of the incarcerated people. For example, the survey of number of cases set a link between the working group and the other institutions to implement the elected actions, lectures and training for defenders, judges, and prosecutors, proposed elaboration of material on the importance of basic documentation, institutional video development addressing the importance of birth registration to be displayed at visitor registration centers, propose a schedule of interviews in the units by social workers, and so on. The most important project aim is to reach prisoners who don't have a civil identification, to formally register them and reintegrate them to society in a country full of bureaucracy, rescuing their citizenship and ensuring the most basic human right to be identified and exist towards the state. Thousands of children live in the streets of Brazil, growing there. For the vast majority, this means the absence of an identity document. They do not formally exist. They are not accepted in health services. They cannot attend the school, cannot claim social benefits, or enroll in government programs. This problem usually lasts into adulthood, and these people only get out of bureaucratic invisibility by committing some offense. Their only legal record is the one where they play the piano. That's an expression that we use because they have to leave their fingerprints when they enter the system, when they are arrested. Without birth registration, you cannot obtain an ID, a voter's title, or a work permit. Some stories are really dramatic. They try to get back into civilian life, get a job, but they do not even get a document that identifies them as citizens. Unfortunately, the lack of a public policy to address these cases is real and clear. The exercise of the right to identity guarantees the right to nationality. The Inter-American Court of Human Rights, in a very important precedent in the Inter-American system, the Yan and Buzico girls versus Dominican Republic case, sets that without a civil birth register, a person remains stateless, and statelessness in turn precludes the enjoyment of civil and political rights of a person, causing a situation of extreme vulnerability. Also, the Serrano Cruz Sisters versus El Salvador case states that the right to identity is closely linked to the right to recognition of legal personality, the right to have a name, a nationality, a family, and to maintain family relations. It's also foreseen in the American Declaration of the Rights and Duties of Man, the International Covenant on Civil and Political Rights, and the American Convention on Human Rights. An important international document produced by the Ibero-American countries, the 100 Rules of Brasilia, expressly names persons deprived of their liberty as persons in situation of vulnerability, since they face special difficulties in fully exercising their rights. In Brazilian law, the position of citizenship and the dignity of the human person are two of the foundations of republic. In order to ease the registration and issuance of IDs, the judiciary has begun conducting video conference hearings for this purpose, used before exclusively for criminal hearings, contributing to the safety, speed, and cost of the procedure. Only in 2015, a law was passed that determines the registration in the maternity itself, but two factors hinder. Not all poor women have their children in hospitals. Special strategies were defined, such as the organization of itinerant services to guarantee the right to birth certificates and basic documentation, especially in the various specific population groups like indigenous people, gypsies, quilombolas, street people, rural workers, collectors of recycled material, and people with difficulty accessing the offices and bodies issuing basic documents. Thus, a questionnaire was developed for the interviews in prison units, where information is collected on whether they have contact with family members, personal life history is asked, name of parents, whether they were in an orphanage, where they were born, if they were baptized, got to study in some college, if already voted in elections, if already served to the military, and so on. In this way, booklets are being prepared to be distributed to the relatives of the prisoners assisted by the Public Defender's Office, and also for health service agents to raise awareness about the importance of the civil registry. It's not uncommon for us to assist people of advanced age whose children, grandchildren, and great-grandchildren do not have the record, enabling all those generations to have a birth certificate. The project participants were divided into 3 teams: the Public Defender's Office, the Judiciary, and the Penitentiary Secretary of State. During the visits, social workers from Defensoria will lead the prisoners' interviews using a standardized form, and after completing these forms, diligences will be made to obtain the documents. In case of need, the result of the diligences will lead to late registration access. And it's important to tell that Defensoria has, although we have more than 800 public defenders, we only have 8 social workers to do all this work. So it's going to take some time to get to the end of this project, to reach our aim. Upon obtaining these documents, they will be delivered personally to the prisoners, or in case of freedom, they must be withdrawn by them at Patronato Margarino Torres, in the case of a prisoner who has been granted conditional release, or in the Criminal Institute Cândido Mendes, 2 institutions in Rio that deal with people that get released. The interview started 2 months ago, and we face some difficulties regarding the number of social workers, as I have just said, available to do the interviewing. Until now, more than 200 detainees have been interviewed, and among them we have found 51 without registration or IDs. With these actions, we can help these people to be reintegrated in society. Thank you for your attention.
Thank you very much for a very unique and interesting experience and sharing that experience. And Ms. Hadel Abdelaziz is going to present the experience from Jordan perspective. She is representing Justice Center for Legal Aid.
Hello everyone. Thank you for having me here, and thank you for attending. My name is Hadil, and I'm the executive director of an NGO in Jordan that's providing legal aid, but also trying to create change and in order to create systems that are actually replicable, that hopefully will be adopted by the government of Jordan or by the Bar Association or any other organization that is willing to take on the projects and the cause of legal aid and make it sustainable. Part of what we do is we provide legal assistance in criminal cases. We have a criminal justice unit. And since our establishment 10 years ago, we would always receive cases for people who we were representing in criminal courts. We would get a lot of allegations of torture. Many people would say they have been either tortured or abused or mistreated in police stations. Most of them would be too scared to come forward and to submit a complaint. Many of them actually were not at all interested in doing that because they had no faith in the system. They were scared of retribution. On the other side, the government of Jordan has done really good work in trying to limit torture in detention centers, in rehabilitation centers. However, it continued to exist, and the problem continued to be very much visible in police stations. The National Center for Human Rights has actually documented several cases and has documented that there was an increase in number of cases being reported where there has been some kind of mistreatment in police stations. On the other hand, it has always been denied, like this is not a systematic problem. It is an individual cases. So always the government would not accept any kind of recommendation to try to limit torture or to end torture because they did not even acknowledge that it was a systematic issue. Our proposal was that, okay, you do not have to acknowledge it as a torture issue, and this is not our fight. Having a lawyer in the police station would actually prevent torture without the government having to officially acknowledge that they are trying to stop torture. So our goal was to work on ensuring that everybody in Jordan was having at least the right to a lawyer. And there were different challenges. The first one of them was legislative. So our law, our criminal procedures law, does not guarantee the right to a lawyer. It does not forbid it, but it does not state it as a right. So our criminal procedures law says that every defendant will have a right to a lawyer as the prosecutor, but it does not mention the police. Also, it does not grant the right we don't have the Miranda right. So people don't know what they are charged with, and they do not know, they are not informed of any right of counsel. On the other hand, there's also institutional resistance. It's not just legislative, but also the police in general always thought that it was not the place, or there was nothing that a lawyer should be doing in a police station. So it was very interesting when talking to you and hearing for the last 2 days. Feels, it's so natural. I don't even have to preach to the choir. We don't have to argue on what is basic, right? It is not very basic. It's not basic at all. In fact, the right that is ignored for such a long time, it becomes contested. It's almost as if it's not existing. Another thing is there's the culture. Because of decades of not having lawyers in police stations, people actually did not even think to call a lawyer if they were asked to go to a police station. So it was a culture. Studies showed that 99% of people were not represented in police stations. 99%, which means that not only the poor, in general, people were not using lawyers or not asking for the services of lawyers when they are arrested at police stations. Another thing is that the culture among lawyers themselves, many of them would say, why would I go to the police station? There's nothing that I could do. Because, again, decades of malpractice meant that they could be themselves either threatened or they are mistreated or at least insulted. Many lawyers think that it's humiliating to go to the police station, so they refused. So This was a pilot to create change. It was important to deliver the services. But the whole idea is that by delivering services, you are trying to create cultural change without changing the law. So the first thing we did was we analyzed the law, the existing law. It was obvious. I mean, we are advocating to change the law for 10 years now. And this year we had a really important amendment to the criminal procedures law. We pushed for amendments so that the Article 99 in the law would be amended and the right to access to a lawyer would be mandated. We were not successful. So our option was, let us use the existing framework. We analyzed the legislative framework that's currently happening in Jordan, and we found out, although that the law does not mandate representation by a lawyer at the police station, it does not it doesn't say that you do not have the right. So this means that it is a general rule that all criminal laws should be interpreted to the best interest of the defendant, because unless it is prohibited, then it is allowed. If it's not prohibited, then it is allowed. Another thing is, so what we did is we actually conducted a program where we have retained the services of lawyers and we operated a hotline. The first thing that we did, there was one thing that I did not mention, that the Jordan Bar Association's law gives the right to the attorney to represent their clients in the police stations. Yet, it was not acknowledged, it was not implemented, because many times the police would say, no, this is not our law, this is the lawyer's law. We selected lawyers by conducting generic trainings on general fair trial standards, access to pretrial representation, and then from the lawyers we trained, we actually got shortlisting and applied, and then we contracted several lawyers who were then trained with a special training. One of the trainings that we give is to train the lawyers what to do if you are denied access to your client, what to do when they will not allow you. I apologize. Yes, thank you very much. Thank you. What to do if you go into a police station and then they say you can't see your client. Our training says don't even talk to them. Talk to the head of the police station. If you're not successful, then you go to the directorate, to the police directorate. And then you submit a complaint to the police. We have a unit that's called the Transparency and Human Rights within the police, the PST. So you actually submit a complaint. If by then you are not successful, then surely your client has been tortured. So you go ahead and you start a process of sending notice to the prosecutor that you suspect there has been a torture case. The only time they will be so adamant of not allowing a lawyer to see the client is when something is wrong. So this was part of our training. It was an escalating steps. And every single lawyer got that manual of what to do and what to do next. And it was a very interesting project. Part of the things that we had to do was to ensure that we had procedures in place. We could not do it ad hoc, so we had a manual for lawyers, manual for people who were managing the hotline, training for the hotline officers on even what kind of information to give, what kind of questions to ask, how to do referrals, what to do if there was a selection process for lawyers based on geography, based on timelines. We had every lawyer would register where they wanted to serve and what hours, and if they wanted to shift their hours, they would actually call the hotline officer. Of course, then there was identification of cases based on complexity. We identified complexity factors, and that was also, again, something that's very much homegrown. We had no system where we could copy from, because it had to be relatively not expensive, and it had to be simple. We could not afford a very complex data system. So it was done by Excel sheets that were locked with the formulas. All the data was kept, and we were actually tracking durations and timelines because we wanted to see how much it would take a lawyer to get to the client, because this was very important, because one of the things that the police was claiming, having a lawyer would delay the investigation. Having a lawyer would be actually something that we have to resist. They did not trust the process. So we wanted to show them that it can indeed be efficient. This is an example of, if you would, thank you. So this is an example of our procedure manuals. It just shows like a simple thing. So it goes to the hotline officer, and then there were questions that they are trained to ask. Based on that, if it's simple enough, then maybe information can be given on the phone. If not, then it has to be referred to a lawyer, a duty lawyer. And after 2 hours, they would have to call back to ensure that the information that they gave was sufficient to solve the problem. Because after 2 hours, things could go wrong. So we would actually then re-refer it to a lawyer. We had a problem with outreach because we were too scared to just go online, and we were worried that we will get like thousands of cases where we could not handle. It was just a pilot project to begin with. So we actually started by giving the number only. We put it on our website and then started to give it to our partners, 79 referral partners. Many of them are actually working with Syrian refugees. So you would see that the nationality of the people we are serving are, like, interestingly, the highest nationality was Syrian, then Jordanian, and then Sudanese refugees. And that had to do with our outreach. We believe that once our second phase starts and we go just national, Jordanians will be definitely the highest rate, the highest population that we're serving. Outcome of the service, so we were successful in achieving release only in 36% of the cases. 55%, nothing happened. They actually continued to be detained. But still, our training to the lawyers that it is not your role. You're not there to release them only. This is not our sole objective. Our sole objective is, number one, they know they are not tortured. Number two, they do not confess to a crime that they do not understand or they have not committed. And number three is to observe the detention periods, because the Jordanian law only gives 24 hours to the police, and then the person has to be referred to a prosecutor. In many cases, that duration was not observed by the police. Also, you see here there's an execution completed, which means that this was a debt. They were arrested because they were in debt. It was an execution case, a civil execution case. Unfortunately, the Jordanian law still allows for imprisonment of debtors. As I said, we had a problem in our outreach, and this is something that we think we would like to think that we're solving now, and we expect that next month we're going to start advertising our hotline number more and more, which would probably put a lot of pressure on our resources, but we believe it's about time we do that. The outcomes of the pilot are always constantly documented, and then they are shared with our partner, the Public Security Directorate. One of the things that we noticed that people were always detained, the 24-hour period was never observed, and the way to work around it was they would actually move the detainee from one station to the other. So what we did in our hotline, and because we have a network of lawyers in more than one city, what we do is we would chase them, follow them, like they're moved from one police station to another directorate, or sometimes to a directorate in another governorate. Our lawyers from the other governorate would be following them, which meant that in many cases this strategy became useless. So hopefully this again will help change culture and limit these practices. Interestingly, like when we started, we thought like the torture is so predominant. It's a very major issue. I still believe it is a major issue, because what we found out that 3% of the people who use the hotline have actually reported abuse or mistreated. 3% is a lot, but it is not as major as we had thought it is. Sometimes the stories of things that go wrong are much bigger than the actual problem. So in fact, this is good because it can actually tell the government of Jordan, this is a simpler case than you think, and you can work on it and you can solve it. Other things that had to do with unification of procedures. So it was totally ad hoc. One police station would actually accept lawyers, the other would give them more trouble. But interestingly, as we went along, every single one of them became more receptive and more cooperative. In fact, my colleagues told me that now one police station is actually calling us in cases that were, in their opinion, simple enough. Okay. Our number one, and that's the takeaway of this pilot, culture can be changed. It is sometimes easier than we think, because we always think that the easy way is an up-down approach. Not really. Sometimes if we can't change the law, we can work within the existing legal framework and change and protect people. Thank you.
Thank you very much. It was very impressive, and I guess that you must be proud to be part of this changing the culture. So yeah, thank you very much. And now let me introduce Ms. Natalie Rea, President of Court Access Program, and she will share experience about the app, which goes to for. Okay, you have a shot? Yeah. 2 minutes. Okay. Yeah. The microphone is not.
Thank you for actually still being here. And I'm really happy to introduce for the first time the Court Access Project, which is a very new NGO. We've presented it at different private meetings in New York, and you're the first public rollout of this project. The sole purpose of the project is to eliminate delays between arrest and first court appearance using technology. SDG 16 recognizes the problem of global pretrial detention. Somebody mentioned we separate that into post-charge, pre-charge. We go a little further, and we take pre-charge as pre-first court appearance and post-first court appearance. The key, in our view, to limiting the problems and the abuses, both before, certainly, let me go back. Every statute, every country in the world provides for a timeline for the first court appearance. It is key for any prosecution to have that timely judicial oversight. It's important for torture reasons. If a person is detained and must be presented to a court within 24 hours, and that person is not going to be, if that person is presented in court, they will not be tortured, at least not in a way that can be apparent. So, I mean, some of you, it may come as a surprise that there are people, primarily the poor, who find themselves detained and essentially forgotten in detention centers for not only days, months, but years. I have been called once working in a country by a judge who had identified and found 40 detainees who had been there for 4 years and never seen a judge. So it is a problem, but it doesn't have today, in 2018, it doesn't have to exist anymore. And I'm not the greatest tech fan, may I say, but yes, the answer, as everything is today, is an app. And so let me introduce you to the Court Access app. It is simple, it is cheap, it is user-friendly. I'm going to describe what it's going to do, and then I will show you the show. The idea is that police officers will download into their phones or be provided with phones with this system. At the time of arrest, they will input the name of the suspect right there on the street. The app, as you know, with its GPS capacities, will auto-populate the information of the place of arrest and the time of arrest. And because every country has a timeline, maybe 24 hours, 48 hours, 72 hours, whatever it may be, before you appear before a judge, the app will calculate that. So if you're arrested today, November 15th, the app will calculate that you must appear by November 17th. That information will be shown on the phone of the police officer to the suspect. The suspect is its best lawyer as far as that goes. Once the suspect has that information, by November 18, he or she is going to say, sorry, I was supposed to be in court yesterday, okay? And that's it. They're not going to stay in for 4 years. The officer just then submits. You know that button, submit, and that information will go to the court. And it will notify the court and place on the calendar for November 17th the name of that person. So the court calendar will see arrest of Mr. X or Ms. X. You can click, and the information that was entered by the police officer will appear. It can be information if you have, and I'll show you, if you have a barcoded ID somewhere, the app will simply scan the ID. You can take a photo if that's what that jurisdiction requires. So now, introducing for the first time in Georgia, the Court Access app. Here it is. So this is how it works. It's not YouTube, huh? Don't expect. This is simply to show that most countries in the world have a time frame. It is it's very rare even to have the language prompt appearance. I mean, that's the exception. The police officer downloads, presses the icon as you do for Facebook, and then he signs in as you do for your Facebook and Instagram or whatever. I want you to see that it's in Georgian also. This is for our hosts. Thank you very much. Okay, and this provides this could be assigned ahead of time. So if you have a barcoded ID, you would press barcoded ID and just scan. If not, you press enter info. And this is the information you enter, right? So you put the person's name. It can be different identifications per jurisdiction. Like I'm thinking of Afghanistan, probably you would have the father's name as ID. So that really depends on what is required in the jurisdiction. As you can see, you can enter gender if you want. The location is just simply that you don't have to do anything about that. Don't do anything about the time. And then you can have a photograph, and I'm sure most of you may recognize Charlie Chaplin. Once you confirm that, the screen to the right is what appears on the person, on the cop's phone, on the police officer's phone. He shows it to the suspect, and this is the information the suspect will remember. At the top, you can see his name and the date of his court appearance, which is key. That's all the information we need. Okay? And this is what the court receives. It's a little small, but you can see it says today's arrests. So the court will have that auto-populating its calendar. So if it's with a court clerk, generally, I mean, in most jurisdictions, there's a court clerk that will go from there to place it on a specific judge's calendar. And then the court will say, if that person doesn't show, where is Mr. X? And this is what makes the difference. The court now knows this person's been arrested. This person cannot be lost in the system. It's not possible. So we have a backup, which is that some people suspect that maybe police officers, and we can discuss it, will not use the app. I don't believe that, but I think that we can all agree that apps have changed our conduct in many ways. We do many things, and I think it can also change the conduct of police officers at the time of arrest. If, however, the police van arrives at the detention center with 5 guys in it, let's assume they're men, and there's only 4 people are it will have received all the information. Only 4 people are listed. The detention center can also enter the same information, and the court will be notified, but it will show that it's arriving from the detention center and not from the arrest place. Okay, if I go back, on the right, there's a link there for the court. If the court clicks on the link there, it sees the same information that was entered by the cop, by the police officer. Okay, so that is the overall, that's pretty much the presentation. Obviously, this can have a lot of consequences for early access by a lawyer. The point of the app is timely judicial oversight, getting the courts involved when they're supposed to get involved. Because I think that one of the big problems of these delays is, first of all, lack of communication between police, detention centers, and courts. Also, the understanding the police officer thinks his job is to arrest, not really to appear for the arrestee to arrive in court on time. The detention center's job is to detain, again, not to bring the guy in on time. But so we need the courts to step in when the legislature told them they needed to step in. It wasn't for nothing. And we've accepted things like, oh, the van is broken, there's no gas, there are a million reasons why this doesn't happen. But the information that one can gather with the app, without being the threat of big data, can show you can show some trends. You need to go to court 5 times a week. You can decide what kind of gas you need. And so the ministerial things that this can help with are not minor. So we are here. We are very happy that you've heard this for the first time. And we're looking to start a pilot project with an impact study in May. We're happy to have a country here that has expressed its interest in having us. And if you think your jurisdiction would like to try this because you think there is a problem, you can go to our website. It says pilots, and you can sign in. And we're picking jurisdictions where we think, of course, it will work very well. But maybe we should pick one where we think it's not going to work at all. So we'll leave it up to you. So thank you very much for your time.
Thank you very much. Oh, yeah. And Ms. Suzanne Lee, Access to Justice Advisor representing British Council. Yes, for sure. Yes.
I really want to thank so much the conference organizers as well as our Georgian hosts for what has been, I think, a very thought-provoking and very interesting 3 days of this conference. And just so you know, I'm a former public defender from New York as well, and there's nothing as inspiring as hearing from people like my fellow panelists about the great work that they're doing and the good fight that they're still continuing to fight. I am the Access to Justice Advisor for the My Justice program in Myanmar. My Justice is a 4-year access to justice program funded by the European Union and implemented by the British Council. We take a very grassroots-up approach. We work with local civil society organizations to ensure communities better understand their rights and how to claim them. We work to ensure justice services, whether they're provided by the government or civil society, are more effective and more responsive to people's needs, and with a special focus on strengthening criminal defense for the indigent accused. We also work outside of the formal system. We work to make community-based dispute resolution mechanisms more fair, inclusive, and accountable, because most people in Myanmar seek to resolve even criminal disputes outside of the formal system. And finally, we conduct research and share lessons learned to inform justice sector policy and implementation. And while we don't have enough time today for a deep dive, it is essential to have some understanding of Myanmar's context. for my presentation today. It is enormously complex. And I will ask the forgiveness of all of my colleagues here from Myanmar for oversimplifying what is a very complicated history. Myanmar is transitioning out of 6 decades of military rule and is moving rapidly towards a civilian-led government. Rapid changes have been underway not only in the political realm, but also economically, socially, and technologically. This history has left an indelible mark on the relationship between the state and its people. And research conducted by My Justice shows that the public perceives the law as an instrument of control and oppression, rather than as a source of rights and protection. And while most ordinary people understand basic concepts of justice, people do not associate justice with law. And public trust across all government institutions is low, but unfortunately it is lowest amongst the justice sector institutions. Now, there are many opportunities amidst all of this change, and one is the rapid adoption of new technologies. Now, 5 years ago when I arrived in Myanmar, mobile penetration was only at 7%, and a SIM card cost me $200 US. Today, mobile penetration is at 90%. SIM cards cost less than $1, and it's estimated that 85% of the people who own mobile phones use a smartphone, which is much, much higher than the country where I'm from, the United States. So suddenly, we have millions of people who never accessed the internet before, who have powerful computers in their hands, capable of delivering extraordinary amounts of content and presenting a unique opportunity to democratize access to information. So we asked, can we use this opportunity to begin to rebuild public understanding of the relationship between law and justice, between the state and society, between duty bearers and justice seekers? So we collaborated with a local Myanmar tech company called Coco Tech to develop what we call the Lanpia Access to Justice mobile app. Lanpia means show the way in Myanmar language, and that's what this app is all about. We aim to inform people about their rights, connect justice seekers to the people who can help them, and to empower ordinary people to take steps towards claiming their rights. So Lanpia contains extensive, easy-to-understand, know-your-rights content, especially on the rights of the criminally accused, as well as rights relating to land, labor, women, children, LGBT people, as well as how to access civil documentation, which is also a very, very big challenge in Myanmar. It also contains a glossary of terms for non-lawyers and non-legally educated people, and links through the legal aid Know Your Rights content to Myanmar laws. There is also a news feed, which you'll see scrolling through here, similar to what you'd see in Facebook, but rather than seeing photos of your friends' children and their pets, it contains rights-related content drawn from research in Myanmar, drawn from the Know Your Rights content, drawn from civil society organizations, news from the justice sector institutions, as well as inspirational stories of ordinary people and civil society actors, legal aid providers, seeking justice and achieving success. There are also quizzes that the users can use to test their knowledge, and links to external resources provided by the government and by civil society. We will be translating all of the Know Your Rights content to at least 3 of the many, many ethnic minority languages used in Myanmar. And next, there is what we are calling How May I Help You? But what it is a chat bot. So for anyone who is technologically savvy, you'll have a sense of what that is. I'm not technologically savvy, so. But it's basically an automated guide that guides the user through a series of questions to determine what kind of information and next steps is appropriate for that user. So it's based on what we know from our research are the most common problems and commonly asked questions in Myanmar. So that's what happens when I get arrested, what do I do? It has to do with how do I register my land? How do I file a claim for land that has been taken away from me? How do I get civil documentation? things like that. So, for example, a person who indicates that someone has been arrested by the police will receive the most relevant information, namely that they have a right to a lawyer from the time of their arrest, their right to remain silent and not to be forced into a confession, and it prompts the user to contact local legal aid organizations and lawyers. The bot also provides step-by-step information about what comes next in the case, and especially on non-criminal matters, step-by-step instructions, for example, on how to register one's land or file a claim in an employment dispute. Of course, this bot is not intended to substitute for competent counsel from a lawyer, but by walking people through different rights and the processes that they will be facing in a particular situation, we hope that it gives people more confidence to engage and to advocate for the protection of their own rights. Now, people in Myanmar also generally don't understand that it is the role of the lawyers to protect clients' rights. So we also provide what we are calling an FAQ, or frequently asked questions, that act to empower clients and empower clients in their engagement with lawyers. It also, we hope, will serve as a bit of a check on the lawyer's behavior when the clients actually know what their rights are and what the lawyers are supposed to be doing. They are able to actually check their own lawyers. As Rick Jones said earlier today, client first, client last, client always, and we really hope this helps to set some of those expectations in attorney-client relationships in Myanmar. The app also contains directories of lawyers, which are searchable by location, specialization, and whether they provide pro bono or legal aid services. And we are very grateful for the support of bar associations, including the president of the Independent Lawyers Association of Myanmar, in helping to get lawyers to sign up and include their profiles in this directory. The app provides directories of civil society organizations who provide a constellation of services that clients need, not only legal aid, but drug rehabilitation services, land advocacy help, victim support, psychosocial services, microfinancing, and other services relevant to breaking the cycle of poverty and incarceration. So, and finally, thanks to the cooperation of government institutions, the app will also provide, for the very first time in Myanmar, a nationwide digital directory of the courts, law offices, which are the prosecution services, and police stations. And all directory listings will include phone numbers that you can call straight through the app. Now, the app is not yet in use. It launches in 2 weeks. And over the next year, we will be working to monitor how people are using the app to better understand what kinds of adaptations are needed, what are the most useful types of content, what are the types of information that people are most likely to read and to share, who is being called through the app, and we will keep returning to the drawing board to redesign to make it more useful for people in need of services. We will be promoting the app widely to the general public, but also disseminating it in a much more targeted way to the service providers, the frontline providers, the intermediaries. That includes people from the government and civil society, including local administrators, which is where most people in Myanmar go when they have a justice-related issue, legal aid providers, and hopefully through a partnership with the Union Legal Aid Board, community-based paralegals, civil society organizations, and of course from other sectors. It's very important to build these partnerships and understanding. We want to reach out to community health workers, librarians, educators, other frontline providers of services who work at the grassroots, and while many of them may not be lawyers or otherwise legally related, they are the de facto advisors and paralegals by virtue of their positions of trust within the community. Now, we are under no illusion that this app, a single app, will address all of the challenges that Myanmar faces. And generally, I'm pretty skeptical of technology as well, and especially skeptical of apps. But we do hope that through our outreach and the use of the app, governmental and non-governmental service providers will be better connected to each other, and that referral networks and trust will be strengthened between them. And we also hope that by putting the law into people's hands in this way, with concrete step-by-step guides to what it means and what can be done, we can begin to empower people to take back the law as a tool for protection and to aid their fight to change their own lives for their better. So thank you so much for your time, and please take note of our Facebook page. If you like the Facebook page or follow it, you'll be updated with information as the app launches and when we learn more about what's happening with it. So thank you so much again.
Thank you very much. Very interesting experience, and we all have maybe I'm sorry? Yeah, okay. Yeah, so the question would be how to reach out to people. So I was thinking in parallel, what would be the challenge for that app? So that looks very interesting. It might be very effective. The only thing, the first step is you have definitely the plan how to reach out people. So more and more people are engaged to download the app and then use it. And Mr. Ivan Honcharuk will share from UNDP Ukraine additional experience about the app and using the app effectively in our services.
Good day, colleagues. And after Susan's presentation, I can say that we have the same, but a bit less, actually. Now, I work for the Recovery and Peace Building Program UNDP Ukraine, and one of the priorities of our activities is to ensure and improve access to justice for local population, and most of all for all for the vulnerable groups, including those affected by the conflict in the east of Ukraine, first of all in Luhansk and Donetsk region. People need to normalize their lives, which obviously is impossible without the restoration and protection of their rights and accordingly legal support. The constant need to contact governmental authorities forms the need not only to inform people about the realizations of their rights, but also about the existence of such rights. Now, according to the data from the State Border Service of Ukraine, about 4.5 million persons crossed the line of contact in the government-controlled area just during the current year. The latest research of the NGO's Right to Protection shows that intention of about 80% of these people is to address certain legal issues. Just during the current year, more than 14,000 court decisions were made in both Luhansk and Donetsk region regarding the establishment of the facts of birth and death in the non-government controlled area. In other words, people require knowledge on how to realize their rights. Another example is the number of cases of issuance and extension of restrictive prescription, a document that can be issued by a court in the frames of civil proceedings in case of domestic violence. This document identifies one or more measures to temporarily restrict the rights of the offender or impose certain legal obligations on him or her. According to the United Nations Population Fund, there are about 1.1 million cases of domestic violence that occur in Ukraine annually. At the same time, less than 85,000 of such cases are reported to the police. However, for 1 year, only 70 cases of restrictive prescriptions issuance have been considered by the courts throughout Ukraine, including 1 case in Luhansk region and none in Donetsk. This shows that people do not know their rights nor the ways to how to realize them. So, how can people get respective information and advice? We try to solve this issue somewhat with a somewhat innovative approach and realize that the best way is to put such an advisory service, if you may call it, in each and every pocket. The mobile application called Your Right became such an advisor. At the moment, the application consists of 3 sections: legal rights of the internally displaced persons, legal rights of survivors of gender-based violence, and advices for implementation of legal rights of these categories in the court. The application does not need an online access to operate. Each section brings together the most urgent questions for each category of persons, united thematically. If different topics overlap, for example, a person needs to register at the employment center and to get the IDP status, the application contains internal links to the respective sections. In addition, The application contains explanations of unclear legal terms, contacts of state and non-governmental organizations that can provide free of charge legal aids, functions of respective state authorities, requirements for procedural documents, rights and obligations of parties during the court proceedings, and rules of conduct in court. All legal advices are provided in non-legal language, which, however, are in accordance with the current legislation. There are also links to the relevant legislative acts. The advices are made in this question and answer form. They provide a step-by-step action plan for solving a particular legal issue. Particular attention deserves a section devoted to the protection of rights in court. The UNDP study shows that the people's attitude to the court depends on their experience in the court. The more experience, the better the attitude. Therefore, we try to reflect the whole trial from the perspective of the applicant or plaintiff. Of course, such a description cannot replace personal experience, but it gives a general idea of what exactly awaits a person in the court, thus destroying a negative and at times stereotypical perception of work of these institutions. And here we placed a QR code in case you want to try it, but of course it's in Ukrainian, so I don't think you understand anything there. Thank you very much.
Thank you very much. As we are short in time, so I guess that we don't have time for questions. Apologize. I hope that we will manage that in the break session. So you are all welcome to somehow, manage that.
Sorry, it turns out we do have a few minutes for questions for the panelists because I think the other sessions aren't back yet. We are waiting to start, and we have our speaker from Parliament ready to make some remarks. But while we're waiting for the other sessions, is there anyone who wants to ask questions? Yeah? Yeah? Okay.
Thank you. Thank you. I would like to ask you, Ms. Susan. You said in your presentation, you, My Justice, cooperate and coordinate government organs, government legal aid board, NGO and NGO, legal provider. So my question is, are you convenient with these organizations and institutions? Let me know your outlook.
Okay, do we have another question over here? Yeah?
Thank you very much to all the presenters. I'm just wondering where, for Christine's app, where the data is stored on the cloud, because that's going to be an issue, one would think.
Is that what you mean?
Thank you.
Did she get all the information she needed? Were they cooperating?
For Christine,
cooperation and collaboration.
which speaker was Christine? I don't know.
Sorry, my apologies, Natalie.
Natalie, yes, Natalie. Okay. Okay, so Susan, do you want to respond, and then Natalie?
Cooperate.
You want Natalie to go? Natalie, go ahead.
The question about the information, is that on? Yeah. One is, once the police officer submits the information, it's gone from his phone, which is very important. He can't go back at the end of the day and figure out what he should have done. And two, the information is going to be in a cloud, like, and secure. And for the moment, and during the pilots, and I believe the first year, the Court Access Project will be in charge of the data. It's very minor data, but it will be in a secured cloud, just like many medical documents are stored.
I'm so sorry, Jennifer. Which question am I answering this? The one from Myanmar? Okay, great. I think the question, as I understand it, has to do with whether we obtain the information for the app through proper coordination with the different actors involved. And it's interesting because I'm surrounded by many of the partners who we worked with, maybe not formally, but we actually worked very closely with, for example, the Supreme Court to ask for information about all the courts. We received the Directory of Law Offices directly from the Attorney General's office. We worked with the Independent Lawyers Association of Myanmar, as well as other bar association, in the recruitment of lawyers to join the directory. So yes, we've worked very transparently with all of those actors to obtain information that we believe is valid, is the official information from all of the different institutions.
Great. Any other questions? No? Okay, good. So I think we have probably about 5 minutes, maybe. We're just trying to get the Melatonin and everyone from the other sessions to come back, Sophie, and then we can start. Yeah.
ძვირფასო მეგობრებო, ბატონებო, ქალბატონებო, ძალიან გთხოვთ. დავსხდეთ ჩვენს ადგილებზე, გავთავსდეთ ჩვენს ადგილებზე. თქვენ როგორც იცით, იურიდიული დახმარების სამსახური საქართველოში არის დამოუკიდებელი საჯარო სამართლის იურიდიული პირი და ის არის ანგარიშვალდებული საქართველოს პარლამენტის წინაშე. რა თქმა უნდა, ჩვენ წარუდგეთ სრულიად პარლამენტს ჩვენს ანგარიშს პლენარულ სესიაზე, მაგრამ ჩვენ ვართ ანგარიშვალდებული ორი უმნიშვნელოვანესი კომიტეტის წინაშე, იურიდიულ საკითხთა კომიტეტი, ადამიანის უფლებათა ქალბატონი ეკაბესელია, იურიდიულ საკითხთა კომიტეტის თავმჯდომარე, რომელიც წინამოწვევის პარლამენტში გახდა ადამიანის უფლებათა კომიტეტის თავმჯდომარე და ჩვენ გვაქვს ძალიან კარგი გამოცდილება თანამშრომლობის.
We have a very good experience of cooperation. So since we became independent and since we started expansion of our mandate and the fact that we developed our functions, it is thanks to the Parliament and personally thanks to Ms. Ekabeselia. She's been supportive at all times and she's here now. She would like to address you and say a few words on this conference, please.
I would like to express my gratitude to all participants and welcome in Georgia. I'm very happy to be here with you, and I think it's very, very important conference. And thanks, first of all, organizers organizing this very, very important, very useful, very interesting conference. It's me. I will continue my national language.
Ladies and gentlemen, I would like to greet everyone. I would like to thank you for holding this important forum. Thanks for the conference. I would like to welcome you on behalf of the Parliament of Georgia, the Legal Committee of the Parliament of Georgia, that is the friend, the supporter, and of all times supporter and partner of the Legal Aid Service. We are friends, actually, yes. It's not that we only assume a parliamentary oversight over this important service of legal aid, but rather we are supporters, we are helpers, we stand by and we lobby and advocate for the agency, for the Legal Aid Service of Georgia, so that the mandate is executed in an appropriate manner. This conference is important in many different directions. The first very important conference was held in Johannesburg. The second conference was held in Buenos Aires, and this is the third one. And now I'm very happy that my country is the host country for this important conference, and the delegates that attend. I would like to greet and welcome. We have honorable representatives from our friend countries, partner countries, representatives of different sectors, different agencies, the practitioners, the members of the academia, people that represent the public defendant's offices, the legal aid offices. These people are united under the title of protection of human rights, which is the most important value and the most important and responsible process. According to the UN guidelines and principles, legal aid is the precondition foundation and the important element for a fair trial and for the rule of law. It is based on the principle of rule of law and is the foundation for execution and realization of all other human rights. Access to quality legal aid is the important pathway towards implementation of the fair trial, and it is and the Human Rights Convention directly talks about the right, human right, access to justice, and it's is established also in the convention, it is established in the Convention of the Human Rights in all fundamental acts and documents such as the UN Declaration of Human Rights and Fundamental Freedoms, EU Convention on Human Rights, the Covenant on Political and Civil Rights, the Rights to a UN Convention on the Rights of a Child. In all of these important documents, access to legal aid, access to free legal aid is a special tool, is important provision in order to make sure that the human rights are observed and implemented. Sustainable Development Goal number 16, which talks about accessibility. It is in order to support accessibility to justice system. It is important to ensure a sustainable development, and it is important to ensure the development of all the democratic institutions. Accessibility to justice system means that at your national level, in the process of administration of justice, the legal aid needs to be provided so that each and every person are properly represented. In this direction, many important changes have been made in our country. We expanded the mandate of the free legal aid, and we also increased the category of eligible subjects. So we provide free legal aid to in criminal cases and also in civil cases, administrative cases, and the mandate therefore of this agency has been expanded. I would like to mention all of these different panels that were very interestingly addressing the topics. So it was about the establishing the critical role of the legal aid in the field of equal access to justice. It was another panel referred to the eradication of discriminations, of protection of fundamental rights and freedoms. And one of the key goals of a legal aid service is to provide protection and provide the service to vulnerable groups, and I'd rather call them the priority groups. So these are the groups that are in need of protection and service in the first place, and therefore the state has to provide them a particular and very important service. We implemented a series of amendments into legislation, and the Parliament is very supportive of the innovations and the initiatives provided by the Legal Aid Service. Since 2013 until today, we adopt different amendments. As I told you, the mandate was expanded. Currently, the Legal Aid Service is also made available to the victims of domestic violence. It is mentioned precisely in the law, and this way we underline the importance of the provision of the service to these particular vulnerable groups. We also have provisions that cover the IDPs, internally displaced persons, children, persons with disabilities. So these are the groups of persons that the state provides specific safeguards for in order for these people to have access to high quality legal aid service. Therefore, the capacity, the budget is of supreme importance, and therefore these issues are on our agenda on at all times on a continuous basis. Every time the draft budget budget is heard at the Parliament. Currently, we are involved into this particular process. Yesterday, we had a discussion of the budget. Our committee is lobbying for the legal aid service and the increased budget, because every time we talk about expansion of the mandate, it takes expanded capacity, it takes a higher budget, and we always apply to the government and to the Parliament and ask for higher budgets. I would like to personally thank the director of the Legal Aid Service of Georgia, Mr. Benidze. He is an excellent partner, and we have a lot of confidence and trust in this agency. The Legal Aid Service also has a very close cooperation with the Bar Association. We also work with Bar Association. Recently, very positive changes were made into the law on lawyers, on Bar Association, and the lawyers from the Bar Association and the Parliament Legal Committee works together. We are in the same working group. We never adopt any law that concerns them without their participation. Together with them, we provide wordings for the provisions. We agree on different terms and conditions, and that's how we make decisions. I would like to thank the donor organizations, representatives of international institutions, Open Society Georgia Foundation, UNDP, UNODC, EU, the Council of Europe, the Open Society Georgia Foundation, the UNICEF, US Aid, and East-West Management Institute Project, Prologue, support to rule of law in Georgia. All of these and many other organizations are our good partners. All of the excellent changes, important changes that we achieved in recent years was the result of a close cooperation with these agencies and organizations. The reform of the Legal Aid Service started back in 2013. We amended the, we started from on the basis of the initiative provided by the Legal Aid Service, and since they became independent, they report to the Parliament, we hear their reports, and as a result of the report hearing, we draft our recommendations. The recommendations aim at enhancing the capacity, giving them a stronger mandate. And after that, we are also involved in monitoring and oversight over implementation of the recommendations. And last but not least, actually it is a very sensitive topic to myself. Currently I am the chair of the Legal Aid Committee. In past I was the chair of the Human Rights Committee, but before that, for 14 years I was the Defense Counsel, I was the criminal lawyer, the practicing lawyer. For many years I was involved in practice. And as a lawyer, I am a great supporter of the agency. And besides a professional, and besides my job capacity, I have a special attitude towards the Legal Aid Service, and I have a very high sensitivity towards the cases and towards the operation of every individual lawyer and every individual Bar Association lawyer or the Legal Aid lawyer. That's why I'm their supporter. I am a friend, and the Parliament in general tries to do their best and support them in their excellent work. Would like to once again thank you for being here, for being part of this important forum. It was an excellent opportunity for Georgia to host this event. I would like to thank the organizers. They are the Friends of Georgia, and we will of course continue implementation of this good practice. Once again, thanks to Meliton and to all the lawyers that serve this noble profession, and I wish you to be proud of your excellent achievements and contribution to the job of protecting human rights. I can imagine that no other job can give you such satisfaction. Thank you once again. Thank you, Ms. Eka. I would like to once again mention that the legal community is very lucky to have Ms. Eka as the previous head of the Human Rights Committee of the Parliament, and to have her currently as the chair of the legal committee, because she understands us from half a word, and she immediately is into the point. And actually, Ms. Eka was one of the most popular criminal defense lawyers in Georgia, and that's why we are happy, and we always are sure that to a certain extent she will be always supportive, and she will be inclined to provide us with a lot of assistance and make sure that there are high standards applied to protection of human rights. Thank you. Now it's the time that we reach our final destination, and now we will be adopting the document for which we did our best. And I'm also very proud to say that we have another very good partner and friend, Ms. Eka. You have to know about that. Mr. Zaza Namuradze, he is a great supporter and the founder of the systems. I remember it was a year ago, I guess, when we discussed this idea of holding the conference in Georgia. Then we provided the idea to donor organizations, and this is the reality. The third global conference was held here in Tbilisi, Georgia, and this is thanks to Mr. Zaza Namuradze. Thank you. And please pronounce the text of the resolution.
As he announced, so we are now starting the, which is to adopt a resolution, that so-called the Tbilisi resolution, Tbilisi declaration actually. Our conferences in Johannesburg and in Buenos Aires ended with the declaration. Those declarations really provided the framework for our collaborative efforts to promote implementation of many ideas, and a quick review of what has happened in the past 2 years, or 4 years, I would say, confirm how much has been achieved in this area. So I would like to really ask all of you to take this document really very seriously, because everything what's written there really helps us drive our efforts forward, and I hope that it will be as successful as the past 2 resolutions. So we are going to do it in the following ways. So Jennifer Smith, the executive director of the ILF, whom all of you know well, will go article by article, paragraph by paragraph through the resolution, and then we are going to receive your feedback, comments, suggestions, and then as we finalize each paragraph, then we will move to the next section. I would like to ask representatives of the 3 countries which hosted the previous conferences to also join us at the podium. So representative of South Africa, Nicholas Lino from Argentina, and Meliton Benidze from Georgia. So they will help us also to really guide our efforts for finalizing the declaration. So please. All right. So we'll take about an hour. Hopefully this will be enough time to agree on this final document. I would like to ask all of you that as we go through the articles, you put forward your suggestions or comments so that we can revise the document as we work on the stage, so that before end of this session, we can actually have the final document that all of us will vote. As you know, this is not representing the governments. This is the document of the participants of this conference. So it is in all your individual capacities that we are really developing this document. All right, so here we go. So Jennifer, why don't you take us through the document? Yes.
Okay, so let's start with the title. The Tbilisi Declaration on the Implementation of the United Nations Principles and Guidelines on Access to Legal Aid in Criminal Justice Systems and Progress on Access to Justice for All of the 2030 Agenda on Sustainable Development. And I'll just say this follows the convention of the past two conferences. In terms of naming, we've just added there and progress on access to justice for all of the 2030 agenda, as that has something, obviously, we all know and have heard over the last 3 days is very important in pushing our agenda forward. Okay. Okay, and we have then Tbilisi, Georgia, November 13th through the 15th, 2008. Let's go to the first paragraph. We, the participants of the Third International Conference on Access to Legal Aid in Criminal Justice Systems, assembled on the 13th to the 15th of November 2008 in Tbilisi, Georgia, to discuss effective strategies to improve access to justice in criminal justice systems, consistent with the United Nations Principles and Guidelines on Access to Legal Aid in Criminal Justice Systems, unanimously adopted by the General Assembly in its Resolution 67-187 in December of 2012, and the aspirations of the 2030 Agenda on Sustainable Development to achieve more peaceful, just, and inclusive societies guaranteeing access to justice for all.
So, thank you. Jennifer, any question, comment, suggestion? Okay, so there seems to be a consensus on the first paragraph, so we move to the second.
The Third International Conference on Access to Legal Aid in Criminal Justice Systems brought together over 270 participants from more than 60 countries who are legal aid policymakers and practitioners from ministries of justice, the judiciary, public defender offices, bar associations, offices of public prosecution, and international organizations, as well as legal aid lawyers, community-based paralegals, civil society members, and other experts. The conference built on the progress achieved since the first international conference held in Johannesburg, South Africa in 2014, and the second international conference held in Buenos Aires, Argentina in 2016, and focused on addressing global challenges and ensuring access to quality legal aid for the poor and vulnerable, particularly in criminal justice systems.
Okay, the paragraph 2. Anyone having a comment, question, suggestion? Okay, that's great. Let's move to the next one.
3 days of deliberations produced this declaration, which was adopted at the closure of the conference with the request that it be publicized widely to legal aid networks and forwarded to national governments, the United Nations Human Rights Council, regional commissions, the Commission on Crime Prevention and Criminal Justice, the 14th United Nations Congress on Crime Prevention and Criminal Justice to be held in Kyoto, Japan in 2020, and shared in discussions around achieving the Sustainable Development Goals of the 2030 Agenda for Sustainable Development adopted by the United Nations General Assembly and Resolution 70-1.
Okay, so any comment, question, suggestion? Okay, so we carry on.
We reaffirm that legal aid is an essential element of a fair, humane, and efficient criminal justice system that is based on the rule of law and that is a foundation for the enjoyment of other rights, including the right to a fair trial, and that it should be guaranteed by the state as set forth in the UN Principles and Guidelines. We are convinced that provision of effective legal aid services that are provided promptly at all stages of the criminal justice process from the earliest stage possible and that are of the highest possible quality is necessary to guarantee the fundamental right to a fair trial as envisioned by the Universal Declaration of Human Rights and International Covenant of Civil and Political Rights, and is indispensable to improving the functioning of criminal justice systems around the world and decreasing excessive detention and imprisonment.
Any reaction?
Thank you.
Okay, I think we carry on.
Yeah. We acknowledge that there is a pressing need to enhance the quality of legal aid services to ensure that legal aid services are of sufficient quality to meaningfully safeguard the fairness of the proceedings and protect the fundamental rights of suspects, accused, or victims of crime. Further, that states must provide sufficient funding to ensure that there is an effective legal aid system that provides quality legal aid services. We also acknowledge the need for legal aid systems to institutionalize quality measures, as well as a need for having external oversight mechanisms to assess and evaluate services and functioning of legal aid authorities, organizations, and providers.
Okay. Is anyone? Yes, Kaha, please.
Can we specify what do we mean by external evaluation? Does it mean outside the legal aid authority or outside the lawyer or legal aid public defender, specific public defender? I mean, that's my question.
So I think the contributors during discussions, so there's two parts to this sentence, and one was that the actual organizations or authorities or providers should have institutionalized quality measures within the institution, but also that the state probably should have some mechanism for external oversight. We're not specifying what that is. Different systems may have different ways to do that. We've heard a lot about best practices over the last 3 days. Mm-hmm.
So we carry on?
Yeah.
We recognize that legal aid and assistance for civil and administrative matters is also critical to ensure access to justice for poor, vulnerable, and marginalized populations. Access to civil and administrative legal aid and awareness of legal rights, for example, on family cases, labor disputes, and property and inheritance matters, is a powerful means for empowering people to realize their rights and entitlements, address their grievances, and overcome discrimination.
So, anyone having a comment or question, a suggestion? Okay, so there is an agreement. We carry on.
We acknowledge the role of legal aid services in supporting progress across the 2030 Agenda, including on poverty eradication in Goal 1, gender equality in Goal 5, decent work in Goal 8, reducing inequalities in Goal 10, and achieving more peaceful, just, and inclusive societies in Goal 16. And note the need to invest in establishing robust legal aid systems as part of national development and justice sector plans. We recall Goal 16 of the Sustainable Development Goals in particular, and its call to promote peaceful and inclusive societies for sustainable development, provide access to justice for all, and build effective, accountable, and inclusive institutions at all levels. Furthermore, we acknowledge access to legal aid as a critical component of achieving Target 16.3, which calls for the promotion of the rule of law at the national and international levels, and to ensure equal access to justice for all. In particular, we refer to the pledge to leave no one behind as a guide to efforts to provide meaningful access to quality legal aid, especially for populations that face multiple and intersecting barriers to accessing justice.
Any comment or a question or a suggestion? I think we're set with this as well.
We are convinced that legal aid is an essential tool in ensuring equal access to justice for all, and that both state and non-state stakeholders have important roles to play in moving legal aid systems towards the ability to provide meaningful access to high-quality legal aid. To expand access to legal aid, states are encouraged to recognize and encourage the contribution of a wide range of stakeholders and organizations that provide legal aid, including non-governmental organizations, community-based organizations, religious and non-religious charitable organizations, professional bodies and associations, and academia, and should consider establishing public-private and other forms of partnership. Further, states should consider including non-lawyers, including law students or paralegals, and the provision of legal aid services, particularly where there is a shortage of qualified lawyers.
Okay, so floor is open for comments, questions, suggestions. Okay, so we will move on.
We recognize that despite codified guarantees of non-discrimination and equal treatment before the law, minority and marginalized communities frequently encounter both implicit and explicit bias in their interactions with the justice system. Inequity can manifest at any point of contact with the justice system, from policing to sentencing to post-conviction processes. Rates of pretrial detention have remained high over the last 10 years, and often it is minority and marginalized populations that face the largest burden in terms of socioeconomic, health, and personal cost of lengthy pretrial detention. We welcome governments taking steps to recognize and reverse discrimination in their justice systems, and recognize that meaningful access to high-quality legal aid services for all poor, vulnerable, and marginalized suspects, accused persons, and victims is an effective and efficient means of addressing the problem. We also welcome states taking steps in providing access to quality legal aid for the most vulnerable victims of crime, such as survivors of sexual and gender-based violence, people with disabilities, and others.
Thank you, Jennifer. Comments, questions, suggestions? We are good. Okay, thank you. Yes.
We recognize that access to legal aid can contribute to reduce the number of pretrial detainees and prisoners and the prevention of their torture and ill treatment, and that reducing pretrial detention is a key indicator of progress towards access to justice under Sustainable Development Goal 16. To uphold fair trial standards and the right to liberty, it is crucial to inform persons of their right to legal advice and assistance and the consequence of any waiver prior to any questioning and at the time of deprivation of liberty, to ensure that persons meet with a legal aid provider promptly after their arrest and at all stages of the case, including when pretrial detention decisions are made, and to prohibit, in the absence of any compelling circumstances, any interviewing of a person by the police in the absence of a legal aid provider, unless the person gives his or her informed and voluntary consent to waive the legal aid provider's presence.
Thank you. So, any suggestions? Yeah. In the past 2.5 days, there were lots of comments, suggestions coming from many of you who participated in the discussion. So it feels like it's reflecting so many viewpoints, and there is already a strong consensus as we observe it. So
yes, we're moving much faster than we usually do. But exactly. I think it's because we did have a lot of great, diverse participation in the working group, which is fantastic. We acknowledge the particular challenges facing conflict-affected and fragile contexts, and recognize that access to justice, including meaningful access to quality legal aid services, can be a means of sustaining peace and preventing a return to instability or conflict. We affirm the need to provide legal aid through innovative and responsive rapid response initiatives, including for detainees, refugees, and displaced people, survivors of conflict-related sexual violence, and victims of human rights violations, as well as to lay the foundations for sustainable legal aid systems capable of ensuring accessible, effective, high-quality, and credible legal aid services.
Comments, questions, suggestions? Yeah, I think we're good.
With this declaration, oh, we have a question.
Sorry, Mathurin, I could not see you.
Yeah, that's okay. I was just thinking, when we say innovative and responsive rapid response, do we want to mention the point on technology here, about using technology?
Yeah, innovative, so probably we could include, probably, innovative.
It might fit better somewhere else. I think what we mean by rapid response is the fact that there's an urgent need, and so to really think creatively in the absence of maybe legal aid legislation or legal aid systems. I think some people made this point on a panel today. How can we urgently meet a need if there's no existing structures?
Yeah. Okay, we can see later on if we can.
Yeah, we can, maybe where we have a point about expanding access, so we can refer to the capacity of technology to help in delivering legal aid services to more people at a lower cost. So we have a second comment here, please.
Thank you. Maybe I missed, or maybe it's coming, but I didn't see, like, or I would suggest that to include minors in the group of vulnerable groups, because I don't think it was there. It was in the previous paragraph, but maybe it's coming. I don't know. But it's also here. So
minors. Do we go to the previous paragraph? So it should be. We can.
Yes.
That was in previous paragraph.
Yeah, minorities are there in the previous.
Minorities and vulnerable groups.
Yeah. So it is true. We have not enumerated yet any particular groups that might be vulnerable. We do later in the document, when we're talking about specialized services, make some reference to that. I think there was some discussion within the working group that if we start trying to name certain groups of individuals who are particularly vulnerable or marginalized, the list could be both very long, and we could risk excluding some groups that we meant to mention. But we do mention children very specifically down below when we talk about the need for specialized services for particular groups.
Okay, thank you. And also maybe you might consider to mention them as well here, refugees and displaced people. Like to mention children that are not accompanied, unattended. So this is a special group maybe as well, especially for the European countries that have so many.
Okay, so thank you. So there is a part where we indeed mentioned few groups, so yes, we could edit absolutely there. So we could include.
But just to go back to Madarima's point.
Yeah.
And Madarima, you violated our rule of not inserting it in a paragraph that we've already passed. But I do want to go back to that. I think probably the ideal place for it, and Zaza referenced this too, was that when we're expanding access, and that paragraph was earlier on. When we talk about partnerships, including non-lawyers, and I think that may be a place where we can also say, innovative technologies. Mm-hmm.
Okay, so we can incorporate both suggestions. Mm-hmm.
Hi, I think responsive, rapid response may be a bit overdoing it. Rapid response may be enough since we want a document that's less wordy, maybe. Okay. That's the paragraph. Yeah. You see what I mean?
Yes. Yeah. So just like
so we'll
language-wise, we can
responsive. Delete responsive.
Yes. That's easy. So we'll do that. Yep. Thank you.
Yes. So it just says through innovative and rapid response initiatives.
Yes. Exactly. Okay.
Sorry, and just to go back, because we do need specific language because we want everyone to agree. And Madhurima, since you're bringing this up, if you want to suggest, if we go back to that paragraph, we are convinced. And maybe we want to include it
yes.
in the last sentence there. Further, states should consider including non-lawyers. You want to maybe recommend a specific words to include? Or anyone else is welcome to do so as well. I think we're just thinking that...
Just maybe after legal aid services and the use of technology, particularly where there's a shortage of lawyers. Is that what you're talking about?
No, I would not say just limited to the situations where it's a shortage of lawyers. So it's better to, it's probably useful everywhere. So we can, could we do this in the first sentence, at the end of the first sentence?
Mm-hmm. Yep.
Where we...
To expand access.
So, or we add it at the end, saying...
Yep, we have another sentence.
Yeah, so you add a sentence at the end where we say that... so it says to expand access to legal aid, states are encouraged. So then we go further. States may also resort to innovative means using technology, or just saying using technology to further access to all persons. Like it's the same thing. You can either you can mention it here.
just saying something simple like further states should also consider using technology to increase access to, or to expand access to justice?
Yeah, it's more simplified.
Yeah. Further, just at the very end, Betsy?
Yeah. I would suggest that it's not only states, probably everyone, I mean, civil society and private sector here can be very innovative. They can contribute by building apps and doing other things. So I would say,
further, the states may be substituted with we, like we are declaring it, like this declaration.
Yes.
Yeah.
It's open for all.
Right. Or we could say, I mean, earlier
and it could be to facilitate access and not expand access, just say facilitated.
Okay. And earlier on in the paragraph, we say both state and non-state stakeholders.
Also, we may use the word multiplier of human efforts, because technology is the great multiplier of human efforts. So we can just put it part of the sentence. Or why don't we say that recognizing that technology has a capacity to multiply human efforts, we encourage technology innovations to be deployed to expand access to justice. Something. Yeah.
Did
you get it? No.
Yeah, further recognizing technology has the capacity to multiply human efforts.
We encourage all actors, we encourage all legal aid service providers or all actors, state and non-state and non-state. You said that.
Yeah, we encourage both state and non-state stakeholders.
Stakeholders.
Yeah. To consider using technology to facilitate access to justice.
Yeah, to expand access.
Or to expand access to justice.
Maybe instead of using technology, we should say innovations. Innovations including technology, because sometimes, just very brief example, legal aid service goes to the villages to provide these services, and the innovative platforms are used for that purpose. So technology is really limited to using the technologies, but for the same purpose. Here, my suggestion would be that we say recognizing innovative approaches, including technologies.
Okay. So further recognizing innovative approaches, including technology.
Maybe the importance of innovative approaches, including technology, to multiply human effects.
Yes. Okay. Sounds good. Please.
Please, if we will add this sentence, I think also we have to protect the personal data with using new technologies. Using new technology, it's good, but we must have the guarantee that we will not use this personal data in other fields.
Yeah, so it depends on the nature of technology, but yeah, if we are using it in a very broad, in broad terms, so it may make sense to maybe put that safeguard there.
This needs to be rephrased, because the using of technology is the last two lines, if you see, Zaza. This needs to be further recognizing innovative approaches, including technology, to multiply human efforts. We encourage all state actors to consider using technology. It's just like coming again to, state actors to facilitate access to justice would suffice.
Yes, exactly. So we can delete.
We can delete to consider using the second time using technology is just reinforcing.
Human after.
Sorry.
Okay, so Betsy, let me read it. So further recognizing innovative approaches, including technology, to multiply human efforts, We encourage, it says like both state and non-state actors, both instead of all.
To facilitate.
Oh, so that's in the wrong place.
To facilitate access to justice. To facilitate access to justice. That would be more appropriate. Rest should be deleted.
Yeah. Now read it again.
Actually, so I think that the phrase at the end goes at the top. It should say further, we encourage goes first. So just cut and paste we encourage to after further, Betsy. That whole, everything from we encourage to the end. It should say further we encourage and then by recognizing. Yeah.
This is okay.
To facilitate access to justice by recognizing or by using.
By using more appropriate,
Okay, so is that okay?
This is great now. Yeah.
Yes, that's great. I think, and there was a suggestion if we put a safeguard for personal data protection.
So maybe we say with appropriate safeguards to protect privacy and confidentiality?
Yes, I guess, great. With appropriate safeguards
to protect privacy
and confidentiality. Okay. Great. I think we did this. Thank you. We can move to the next paragraph.
Okay, we have to go back. Where were we? Sorry, we were at with this declaration, right? Right before the in line with? Okay.
Yes.
Hey, can you, before you go too far, since you were there, Zaza and Jennifer, can you go back to that paragraph right after the one you just worked on?
Yes, we recognize.
Yeah, we recognize.
Guarantees.
Yeah, the last sentence of that one. The other direction. The next paragraph. There you go. Why do you in the last sentence after the word legal aid provider, comma? Why do you need everything after that? Unless the person. Why do you need that?
We don't need that.
Yeah, I think you should take that out. Yeah.
No, that's good.
Good suggestion. Yeah.
Thank you.
Okay, so we'll move forward to.
Cassie, you wanted to suggest something, or it's okay? So we can. Okay. We move on. So it's now the last paragraph of the preamble.
Yeah. Okay. So with this declaration, we assert the critical role that legal aid plays in ensuring equal access to justice for all, protecting fundamental rights, countering all forms of discrimination, and directing improvements in the justice system, supporting prompt and effective access to high-quality legal aid and the independence of the function of legal aid providers and organizations that provide legal aid services, along with other measures, facilitates the protection of marginalized groups and the reversal of discrimination and disparate treatment. Furthermore, legal aid providers, legal aid organizations, and legal aid authorities that provide or administer legal aid improve and increase these groups' access to the justice system, and with it, the enjoyment of other rights and freedoms.
Okay, so this is the last paragraph in the preamble. Krasi, please.
I think that we should say reversal of discrimination and disparate impact, because discrimination and disparate treatment is the same. There's no disparate treatment is a term, if I'm not mistaken, of the American labor law, and it means discrimination in employment. But disparate impact is different.
Okay.
Let's, if you don't mind.
Agree. Yes.
So just good. Betsy, and disparate
impact. Instead of treatment, it will be impact. Just one word. That's it. Yeah. Impact. Good. Please.
In the last sentence of that paragraph, legal aid authorities that provide or administer legal aid, I think that the first instance of legal aid there can probably be cut. Authorities that provide or administer legal aid.
I think, and maybe we need it's meant to provide to all three of those types of organizations that preceded it, either provide or administer legal aid. So, I mean, maybe we could say further legal aid providers, legal aid organizations that provide legal aid and legal aid authorities that administer, but, you know, so.
No, that makes sense.
Yeah.
It's more inclusive, just, yeah.
If in second line, justice for all, and after comma, leaving no one behind, just to emphasize and
second sentence or which?
With this declaration, we assert the critical role that legal aid plays in ensuring equal access to justice for all, leaving no one behind.
Yeah,
just to ensure.
Yeah, we have actually reference to leaving no one behind.
That's why. That's why.
Would you like this to be inserted here? Yeah, I mean in the SDG.
Just to emphasize. Just to emphasize in the last.
It says that already.
It's there. Okay.
No one behind. Okay. Right. Okay, there was a hand over there, please. Can you use another mic?
No, it's working. I was still at the paragraph we discussed before. Yeah, I'm really sorry.
Yeah, we cannot go back, General, but I mean, try not to go back. But
no, I do understand, but for me, it's like really important to say because I saw that students can give legal aid. And I think that maybe is a terrible thing to write down if we think about minimum standards, because you should try to have like a qualified lawyer or a paralegal. If you say students, that might lower the defense for the people. So I wanted to make a comment on that.
Yeah.
So I don't know why. Maybe it was like really discussed that students should do it, but I think it's not a good idea.
Yeah. So
so
David, please. Yeah.
The guidelines specifically mention students. It's not legal representation. We're saying it's legal advice, assistance, and everything else. It's in the guidelines.
So just to emphasize too, it's a great point. And it does say here, though, just to go back to it says should consider. Not that, you know, it will work in every jurisdiction, but in some jurisdictions, you know, when I was a law student, I actually could practice law underneath a lawyer, right? So who was supervising me. So some jurisdictions around the world do have sufficient safeguards in place for law students to practice because they're underneath the authority of a lawyer, but some don't. So that's why that's why I think that's emphasizing here, you know, should consider different ways of expanding access.
So
maybe it's good to put in supervised students. So put in the word supervised.
Yeah. Can we look at that paragraph? So where that language is.
Mm-hmm. So it's under we are. It starts with we are convinced. Yeah, here, and it's the second last sentence.
I think we would be like blocking the way for the future legal aid providers by just eliminating this section, because the law clinics are now a must component of the legal aid provider things.
So there are countries which they'll engage with student law clinics as legal aid service providers. For example, in Indonesia legal aid institution has agreements with university student law clinics to provide legal aid services if there is assurance that there is, there is supervision of a lawyer or a professor, and or if it's sufficient quality. So, and also it matters what kind of services they provide. Students engage in legal literacy, street law teaching, they may be providing information advice under the supervision or independently. So if we name it broadly,
just go back to the point. I think the point was one of quality, and I'll just say this: this particular paragraph is about access, not quality. There's a separate paragraph on quality, and maybe that's where we can address your concern. Because I think here, of course, a lawyer on day one, you would also want them to be supervised, probably, right? So we're going to get there's a paragraph that we may have passed already with quality, and maybe that's where we can add some language.
Or what we could do is that in this same sentence, we can expand the sentence saying that ensuring that there is the adequate quality, or this is done with the guarantees of quality, and
But I think it should be in the quality section, because then you're talking about everybody who's providing legal aid instead of kind of singling out that one. So there's this if we go back to, we acknowledge that there is a pressing need to enhance the quality of legal aid services.
That is right, but because in this sentence, so we talk about non-lawyers and paralegals and student law clinics, it's good that that sentence includes that there is assurance of the quality mechanism for these providers.
Absolutely. We can, if that's easier, we can do that there.
Definitely, when they are working under the supervision of the lawyers, and they are insured clinics, even during their period they are studying law.
But so we can keep the language more general, saying that with the guarantees of sufficient quality, supervision,
or adequate supervision.
Adequate quality,
quality or supervision, that would serve the purpose.
So Betsy will need a little bit more direction.
So in that sentence, where we talk about the clinic, and non-lawyers, so there's a sentence on non-lawyers.
Yep, so it says further, states should consider including non-lawyers, including law students or paralegals in the provision of legal aid services, where there is sufficient quality,
with the assurance or with the guarantees of quality mechanisms in place. Would it be?
This serves the purpose.
We need the verb are in place.
This serves the purpose.
Okay. Does that address the concern?
Would this be fine? Is it?
Yeah.
Also,
so this reads, further states should consider including non-lawyers, including law students or paralegals in the provision of legal aid services with a guarantee of quality mechanism in place.
Or we can rephrase it as without compromising quality. Without compromising quality.
Yes, please. Sorry, we're trying to edit as we go.
No, just to have harmony, to have harmony in the text, I think we have also to put all forms of discrimination in paragraph 6 when we are talking about discrimination. We add it in the paragraph 6, like
yeah, I thought that this was included, all forms of discrimination.
We include it in the last paragraph, but there is another paragraph where we are speaking about discrimination. We didn't add it.
In the previous paragraph
6.
Okay.
Thank you.
Okay.
We'll just find that paragraph. So there was a. Is it the 6th paragraph? Okay.
So it's you're talking about the last clause, overcome discrimination. So you want to say overcome all forms of discrimination.
Yeah.
So Betsy starts with, it's the 6th paragraph. We recognize that legal aid and assistance for civil and administrative matters. Yeah. And at the very last two words, overcome all forms of discrimination.
Okay. So we are done with that. Good. So I think we are through the preamble.
May I one point, please?
Yes.
Because we are saying that we don't need to leave anyone behind. So not only people, but also countries. So it's important to mention networking on regional and international levels. At the same time, encourage peer-to-peer cooperation or collaboration. Networking.
It's mentioned afterwards. There is a specific part of the declaration coming, which two parts actually. We are talking about specifically about cooperation and networks.
Okay. So great. So it's coming now, actually. So next one. So we're done with this. So we are moving to the second part of this document, which is calling on three different actors. So we start with the state.
In line with the recommendations of the participants attending the conference, we resolve the following. We call upon all states to proclaim and demonstrate political will and commitment to achieve the aspirations and objectives as set out in this declaration, and to fully implement the provisions of the UN principles and guidelines, as well as the related provisions under other relevant international and regional instruments in pursuit of the aspirations of the 2030 Agenda on Sustainable Development Goal 16 and Target 16.3 in particular, and with particular attention to leaving no one behind, by enhancing meaningful access to quality legal aid for marginalized or vulnerable populations, groups with special needs, and those living in rural, remote, or underserved areas. In this regard, we call upon all states to review and, where necessary, amend existing or enact new legal aid legislation and policies, to establish effective systems for the delivery of legal aid, with a particular emphasis on ensuring there are mechanisms and policies in place to provide access to legal aid to all accused who cannot afford a lawyer as early as possible in the criminal justice process, but no later than before the first questioning, to prioritize the dedicated, independent, and sustainable funding of the delivery of legal aid,